Hello friends, Mark Martella here for the Dellutri Law Group. And what I'd like to talk to you about today are the three biggest mistakes people make when trying to do their will on their own. Now, there are online companies where you can do a will, or you can go to your local office supply store and get a will. But again, you get what you pay for. You may not be getting the advice that you need, that you don't know you need in preparing these documents. So the first mistake I often see is a very simple one, but very easy to make, and that is not properly signing the document. Again, here in Florida, we need a will, must have two witnesses. If it doesn't have two witnesses, you're going to run into problems. Also, to make things easier after your passing, we like to have what's called a self-proving will. And a self-proving will is one where it's signed before two witnesses and a notary. And a notary acknowledges not only the signature of the testator, the person signing the will, but also acknowledges the signatures of the witnesses. And by doing that, the will is called a self-proving will, because you don't have to prove that the testator signed the will by dragging the witnesses in. So again, I see these wills that are just signed by the individual, thinking, oh, the witnesses and the notary, that's just extra stuff. I don't need that. Well, if you don't have that, the will may not be admitted to probate. So that's mistake number one. Mistake number two is not considering the special circumstances of your beneficiaries. For example, if you have a wife who is on Medicaid and receiving these government benefits, but you're going to leave her a lump sum, maybe let's say $100,000. Well, now you've just disqualified her from receiving those government benefits until that $100,000 is spent. Whereas if you created a spendthrift trust within your will, you may provide the protection. Also the same if you have a child, for example, that maybe has a drug or alcohol problem. And you don't want them to get a lump sum and go on a spree. Again, we can provide for those things in a will, but if you don't know that those provisions and those possibilities are available because you're just using some form you picked up at a store, it can cost your heirs a lot of money. And then finally, we see this happen a lot. I'll have the children of a deceased parent come to me and say, well, hey, we found this copy of a will in his papers. Well, the problem with that is, under Florida law, the only will that can be submitted to probate is the original will. And so sometimes people want to maintain their privacy, and maybe that's why they didn't go to an attorney and they created their own document. Well, they never told anybody where it is. And maybe sometimes I've had the case where the only copy they can find is an unsigned copy online on the person's computer. They've never communicated that to others. So it's real important that if you do go out on a limb and decide to do it on your own, that somebody knows that you've prepared it. So again, while obviously I would recommend when you're dealing with your estate that you get professional advice, if you do it on your own, make sure it's properly executed. Make sure you consider any special circumstances, and make sure somebody knows where it is so they can find it upon your passing. One little bonus tip I'll give you is sometimes people want to disinherit a child. And so they figure they're going to disinherit them by not listing them in the will. Well, that's not the way you disinherit somebody, because what your child will do is they'll challenge the will, saying, well, obviously my dad forgot to mention me because he loved me and he would have mentioned me. So if you want to disinherit somebody, just ignoring them in your will and not mentioning them at all may just create litigation for your other children upon your passing. If you want to disinherit somebody, you need to do it properly with the proper language in your will. Again, I'm Mark Martella for the Dellutri Law Group. If you have any questions, please feel free to reach out to me at 941-206-3700. We offer a complimentary, confidential consultation to discuss your estate planning needs. Thanks for watching.
If you found the information in this video to be helpful, then do us a favor and like, comment, and subscribe to our channel for more videos.